Good morning. Thank you so much for joining us for today's Wednesday webinar, where we're going to be talking about Social Security disability after a workers' compensation injury. A couple of things I do want to make mention of. Number one, that today's webinar is not meant to be legal advice, but is instead meant to serve as some additional background information for those that have suffered a workers' compensation injury and are now looking at applying for Social Security disability benefits. Number two, you will notice that we don't take any questions on the live webinar. And the reason for that is not because we don't want to help, but because we often need a lot of information to be able to give any type of good response back. And I don't like for that information to be out where other people can see or hear it. And so we don't take any questions on the live. We don't really respond to specific questions put in the comments on the replay. And so to kind of help combat that, what we do is on the live, we'll go ahead and drop that link in the chat now. If you have questions, you can use this link to schedule a call with us. And that way, it's a 15-minute call. We have plenty of time to typically get all the information that we need to either give a better answer or to point you in the direction of somebody who may be able to help. That link, if you're watching on the replay, is going to be down below. We will also post the last slide in here is our contact information where you can give us a call, send us an email, and again on the live, we'll drop that link one more time at the end. So if you do have questions, please do reach out and ask. We're always happy to help in any way that we can. So without further ado, we'll go ahead and get started. Here's our roadmap for today. We're going to first talk about Social Security disability basics, some guidance that the agency may have, some considerations, and then finally, how an attorney may be able to help you with your Social Security disability claim. A little bit about me. My name is Caitlin Wildoner. I'm the founding attorney of Beacon Disability PLLC, which is a law firm based in Florida where we exclusively practice federal administrative law, which means that we assist clients with their agency level SSDI and SSI matters, anywhere from the initial application up to the appeals council. At the time of the recording of this webinar, we are not currently handling federal appeal cases. There are two different Social Security disability programs underneath the Social Security Administration umbrella. SSDI is Social Security Disability Insurance, and SSI is Supplemental Security Income. Both programs are going to require that you be disabled and unable to work for a period of at least 12 months. Where they differ is SSDI benefits are going to require that you have a work history. They're going to require that you have worked and paid into the Social Security system at a certain amount of time. Typically, we say 5 of the last 10 years. Individuals going for SSI benefits, they are going to not have a work history requirement, but there are income and asset restrictions for SSI benefits. We don't cover the income restrictions in the webinar because they vary depending on family size, but asset restrictions are pretty black and white. You cannot have more than $2,000 in assets if you are single and more than $3,000 in assets if you are married. What is not included in those assets is one home and one car. Really anything beyond that is. So any bank accounts, investment accounts, retirement accounts, if you own any property outside of your primary home, if you own 2 cars, let's say you're married, you have a car, your spouse has a car, that second car is going to be considered to be property that is going to be counted towards the assets. When you initially submit your application for SSDI or SSI benefits, the agency is first going to look to see if you've applied for SSDI, do you have a sufficient number of work credits? Have you worked and paid into the system long enough to qualify for and pull from SSDI benefits? If you have not, they will get out a pretty quick denial saying you do not qualify under our rules because you don't have a sufficient number of quarters of coverage. With SSI, they're going to pretty quickly look to make sure that your income and assets are below their threshold. Again, if they're not, you'll get a pretty quick denial saying your income and assets exceed our threshold, therefore you don't qualify for SSI benefits. As long as you meet the secondary prong for whichever program you've applied for, that's when this 5-step evaluation process starts. They're going to look to see, number one, are you engaging in substantial gainful activity? 2023, that's defined as working 20 hours a week or more, or earning $1,470 a month or more in gross earnings. If you are engaging in substantial gainful activity, then you cannot be found disabled under their rules, and they will send a denial at step 1. I want to make an important note. If you are receiving workers' compensation benefits greater than $14.70 a month, but you are not earning that money, you are not working at all to earn that money, but you're receiving it as part of the workers' compensation benefit, that is not going to count towards the substantial gainful activity. You will, of course, need to let the agency know, particularly if you've applied for SSI, that may push out of some eligibility. But you want to let them know that you do have that income coming in, but it is not earned income, that it is the result of an ongoing workers' compensation case. Okay, so that's an important notation to make. If you are not engaging in substantial gainful activity, the agency moves to step 2, where they start to review your medical records. They're going to look to see, do you have at least one severe medically determinable impairment? That is an impairment that is found in the medical records that has some limitation on your ability to perform basic work activities. Okay. If you don't have a severe impairment based on the medical records, the agency is going to go ahead and deny the claim at step 2, saying you don't have a severe impairment, therefore you cannot be found disabled under our rules. As long as you have at least one severe medically determinable impairment, the agency moves to step 3, where they'll look at the listings. The listings are included in the Blue Book of Listings. They tend to be pretty high bars. If you Google the Social Security Administration Blue Book of Listings, it should bring you to the current one. You'll want to make sure you're looking at the adult listings, not the children listings. If we're talking about you with a workers' compensation case. And then you can kind of look, it's broken down by chapters: musculoskeletal, special sense and speeches, cancers, mental health. There's all kinds of different chapters, cardiovascular, where different conditions are covered. And so you'll want to go to kind of the chapter that best fits what you're dealing with, and look to see what the listings are there, to see whether you may or may not be able to make an argument that you might meet or equal one of those listings. If you don't, it's okay. The agency is going to continue to review the claim. If you do, they'll stop at step 3. They'll say you are disabled under our rules. You meet listing 1.02 or whatever it is. I guess it would be not 1.02 anymore. That does not, I don't think that isn't a listing. You'd be 1.17, something like that. If not, they go to step 4 and they'll say, okay, can you go back to your past relevant work? They'll create a residual functional capacity for you, which is what the agency believes you are able to perform based on the medical records despite your condition. Okay, so the activities that you can perform, how long you can sit, stand, walk. In workers' compensation cases, we often see that there may already be a functional capacity evaluation in the file, and so that can be helpful. The agency does not have to adopt that FCE as your RFC. Okay, they can come up with their own RFC that they are supposed to use the totality of the evidence on. So if you have a functional capacity evaluation in the file, that may be helpful at this stage. But again, the agency does not have to adopt that functional capacity given to you by a different doctor. They'll use that RFC that they come up with to say, can you go back to your past relevant work? If you can, then the agency will stop there. They'll say you can go back to your past work, so you're not disabled under our rules. And past relevant work is work that you've performed in the last 15 years, long enough to learn the job. So that's what they're looking at there. If you cannot go back to your past relevant work, they still have that RFC. They look at your age, education, work experience, including any transferable skills you may have gained, and that RFC. And they're going to use it to say, okay, can an individual with this age, work history, RFC, education engage in any other work? Are there any jobs that exist in the national economy that this individual can do? If so, then you will, if there are other jobs, then you'll go ahead and get a denial. If there are not any other jobs that exist in the national economy, then the agency will go ahead and approve it at step 5. The definitions of disability are likely to vary from your workers' compensation case to your Social Security disability case. Importantly, being found disabled by one entity does not equate to automatic disability by the other. That's really hard for a lot of people to understand. My workers' compensation case, I'm permanently disabled. I understand, but the agency has their own definition of disability. And so they're given that autonomy to make that decision for themselves. And so, of course, you want to use their rules and their definitions to prove your disability, not rules and definitions from the workers' compensation case. The listings, Social Security rulings, and other guidance that's issued by the Social Security Administration can be helpful to understand the differences between the two programs. If you spend any amount of time kind of looking at what the definitions are and things like that, you'll see that Social Security does tend to have a pretty stringent definition of disability. But if you are disabled and unable to work, it is absolutely worth going through the process. Medical records are going to be critical, probably very similar to your workers' compensation case. The thresholds and definitions included in the Social Security disability programs, though, are likely to vary widely from the definitions in your workers' comp case. Workers' compensation claims, definitions, and benefits vary from state to state, and so that's why we're not going to provide an overview of those benefits in this webinar. If you have an open workers' compensation case, ask questions for workers' compensation to that attorney. Even if you schedule a call with us and you have workers' compensation questions, that's not going to be something that we can help with. I'm going to tell you to reach out to a local workers' compensation attorney. The medical records, though, from your workers' compensation case, as I said, you may have an FCE from your workers' comp case. That is likely to be relevant in your disability claim, and therefore it might be prudent to ask for a copy of your records from your workers' compensation attorney when that case closes. That way you have a copy of the records for your own purposes, and then you can also share those records with the Social Security Administration. That way they have them as well. I also want to make mention that there may be a financial offset in the benefits that you receive if you receive simultaneous benefits from workers' compensation and either SSDI and or SSI. So that's important. If you're receiving a set amount from workers' compensation, it's unlikely that you will receive total SSDI benefits on top of that. There's likely to be an offset between the two. Here's how an attorney may be able to help you. This is not an exhaustive list, but we can provide guidance on what correspondence from the Social Security Administration actually means. If you are already a client of ours or you reach out to us with sufficient time to file the appeal, we can file necessary appeals. We do review your medical records and case file and can discuss what additional records may be helpful in your specific case. We review your documents for accuracy and completeness, and we can discuss what the agency is looking for in the forms that they send out. Particularly, there's an adult function report that they will often send out. There's often pain questionnaire or supplemental pain questionnaires, supplemental anxiety questionnaire, supplemental cardiac questionnaire, more specific to your condition. And so, like I said, we don't fill those out for you, but we can discuss what the agency is looking for, and we can look at them to ensure that they are accurate and complete before they go to the agency. The reason we don't fill them out for you, again, is not because we don't want to help, but it's because I view them as testimony without having to go before a judge. It's an opportunity for you who is living this every day to explain to Social Security what living it every day is like. As much as we try to empathize and understand, we do not live it. And so I find that the answers to those questions are best created by you as the individual who's going through it day to day. If you have to go to a hearing before an administrative law judge, we do prepare you for that hearing, and we will question you and any witnesses present during that hearing, such as a medical witness or a vocational witness brought by the Social Security Administration. As I promised, here's our contact information. We'll go ahead and also drop the link on the live webinar again to schedule a call. If you have questions, please do take advantage. Schedule a call with us, give us a call, send us an email, whatever it is that maybe we may be able to help, please do reach out. We are always happy to help. Even if we can't, we do try to point you in the direction of somebody who may, so that way you can maybe stop spinning your wheels, hopefully. The link to schedule a call on the replay will be down below. If you have questions, please do feel free to reach out. We're always happy to help in any way that we can. Thanks so much for joining. Have a wonderful day.